Welcome to the webinar, Top Questions for the MAR Legal Hotline. This webinar will be recorded and archived on marealtor.com after the live version. If you have any questions throughout the session, please type them in the bottom of the chat box on your screen, and we will hold a Q&A afterward. Please note, we will refrain from answering any personal, legal, real estate questions in the webinar. You can call the MAR customer service line and speak to the legal hotline for legal real estate assistance. Our presenter today is Catherine Taylor. Catherine joined the MAR professional staff in November 2017 and serves as the MAR's Associate Counsel. Catherine works as a joint point person for local advocacy issues and assists with maintaining policies, procedures, and manuals that detail functions of the MAR governance structure. She also assists members on the legal hotline with questions about current state and federal laws and regulations, permissible business practices, and important court rulings affecting real estate professionals. Catherine is a graduate of Pace University and New England School of Law. The webinar today will review the common legal questions and concerns from the hotline and more. Now over to Catherine.
Thank you, Sarah, and good morning, everybody. As Sarah said, I'm going to go over some of the more common issues that come up on the legal hotline, but certainly feel free to ask questions at the end, even if it pertains to a topic that I did not cover here. One of the most common questions we get pertains to agency and the disclosure that's required. So I wanted to quickly go over what agency relationships are available in Massachusetts and how to properly document those. First, you need to complete the mandatory Massachusetts agency disclosure form at the first personal meeting to discuss a specific property. So there's no requirement that you're actually going to be representing that person. Going forward, you may not get the listing or they may choose to work with somebody else. However, if you're discussing a specific property in any capacity, you certainly want to make sure that you fill out the agency disclosure. Traditionally, many offices have practiced dual agency. So I wanted to go over the differences between what dual agency is in the sort of traditional sense and designated agency that's available for office structures. In dual agency, one agent represents a buyer and a seller in the same transaction. And in traditional agency, an agent within an office that represents a seller, every other agent within that office is going to have that same relationship with the seller. And everybody owes those fiduciary duties to both the buyer and the seller in a dual agency situation. In order to enter into dual agency, you have to have written informed consent from both the buyer and the seller. And you want to make sure that you keep the record of that consent from both the buyer and seller for a minimum of 3 years. And of course, in any dual agency situation, if a conflict arises between the buyer and seller, you want to make sure that you remain neutral and don't take one side over the other. Designated on the agency on the other side is where both the buyer and the seller have their own agent, but both agents work for the same brokerage. Again, you have to have written informed consent from both the buyer and the seller to enter into a designated agency relationship. Typically, we recommend that a best practice is to have an office policy that establishes how each client's information is going to be protected from other agents in the office. So there's no sharing of information, so you're able to do that designated agency relationship. And then, of course, that designated agent only owes that fiduciary duty to their client, and no one else in that office is going to have a relationship with that client. In order to obtain consent to designated agency, one of the most common ways of going about doing that is to use one of the MAR forms that includes the consent to designated agency. Often it's going to be in the exclusive right to sell or in one of the exclusive buyer representation agreements. At the bottom of your screen, you'll see the numbers of all of the forms that do include it. You also want to make sure that you include the names of all the designated seller agents. So certainly there's a possibility that within one office you could have multiple agents that are representing the seller, and you need to have each of those individuals identified on the consent. If and when a designated agency situation arises where the buyer is going to be represented by somebody else within the same brokerage, you need to provide notice. And again, you need to include the names of all of the designated agents in the transaction. The same principles apply for dual agency. Again, on your screen, you'll see that there are multiple MAR forms that allow you to obtain consent to act as a dual agent, and it needs to be obtained from all parties in the transaction. So you can, again, include that in an exclusive representation agreement, or as you see on your screen, as a standalone form that we have. And again, if and when a dual agency situation arises, notice needs to be provided to all parties to the transaction. It can be signed and dated by everybody, including the broker. As far as agency and open houses, this is a very, very common question we get on the hotline is if you want to have somebody cover your open house for you, what agency relationship does that individual have with the seller? You have a couple of different options. If you're in an office that practices designated agency, you may have somebody who is not a designated agent in the transaction act as a facilitator. You need to make sure that you always have your disclosure conspicuously posted. So usually people leave a sign on, a countertop in the kitchen by the information regarding the property that discloses what that listing agent or the agent who's hosting the open house, what their relationship is to the seller. That exception to the rule for not needing the complete agency disclosure form is limited to the hours that the open house is posted for. So if somebody comes in before or after the advertised hours of the open house, you need to make sure that you complete that mandatory agency disclosure form with them. Staying with open houses, wanted to go over a couple points to help you avoid any potential liability. One of the hot topics that seems to be coming up with the increase in technology is what to do if a seller has recording equipment or surveillance equipment in their property. Massachusetts is a dual party consent state for recording anybody, the audio of what they're saying. It's a crime to secretly listen in or record somebody without their knowledge and consent. So certainly this is something that you want to make sure that you're having a conversation with any of your sellers about from the outset of your relationship. Ask them whether they have any recording equipment in their property. That includes everything from the Ring doorbell to the Nest home cameras to Arlo. Google, I think, has cameras as well. So you want to have that conversation and ask them whether there's anything in the property. If there is anything on the property that is going to be recording them, prospective buyers and their agents, you need to clearly disclose that. Our recommendation for disclosure of that is to include it in the MLS that the property is under surveillance and they may be recorded. You should also post something on the property that people will see before they are subject to any recordings. So if the exterior of the home is recorded and it includes audio, put a sign in the driveway. If it's just inside of the house, put a big sign on the front door. But you certainly want to make sure that anybody entering that property knows that they're going to be recorded. You don't need to necessarily have anything signed saying they consent to it. There's no affirmative requirement for that. However, they do need to be notified of it and give a passive consent by entering that property. So that's certainly something you want to make sure you have conversations with your sellers about to make sure that there's no liability on their part there. You also want to have a conversation with your sellers to secure any valuables they have in the house, medications, and weapons. Certainly people walk through houses, open cabinets and doors and cupboards. You want to make sure there's nothing there that goes missing that shouldn't go missing. Have a conversation with your sellers to make sure that all pathways, stairways, entrances are clear. There's nothing that people could potentially trip over or injure themselves on. And if it's in the winter time where there's snow or ice, you certainly want to make sure that that is dealt with appropriately. You as an agent also want to make sure that you do a walkthrough prior to any showings or an open house, just to make sure that the homeowner has indeed made sure there's nothing that's going to potentially injure a prospective buyer or their agent. When a showing is over or an open house is completed, you as the agent want to make sure there's nobody left in the house. That means checking closets, bedrooms, anywhere that somebody could be hiding. Make sure that there's nobody left in the property. Also extinguish any candles or fires that you've started before leaving. Make sure they're completely out and turn off the appliances that you turned on. You just want to make sure that you leave the house in the same condition it was when you got there. As an agent, you may be liable for an injury if somebody gets injured on a property that you're listing. If you had actual or constructive knowledge of a defective condition or hazard, and you failed to warn a prospective purchaser or their agent about that danger. It's when your actions or omissions as an agent are a direct cause of an injury. The common case related to this situation is a listing agent received a home inspection report from a buyer that said the pull-down ladder from the attic was needing repair. It was a danger. The buyer in that transaction ended up backing out of the deal. They obtained a new buyer on that transaction. That buyer and their agent were not informed of the condition of that pull-down ladder for the attic. They pulled it down. When they stepped on it, it collapsed and the agent was injured. And the court did find that there was liability on the part of the listing agent because they failed to warn that buyer and their agent about that condition. And they had actual knowledge. And if they had warned them, they wouldn't have used it, or the situation would have been corrected and there wouldn't have been an injury. So certainly make sure that those types of situations are addressed, because that will limit your exposure to liability. Another question that we get oftentimes on the hotline pertains to escrow. People always ask, when does a check need to be deposited? Can I hold it until after the home inspection? What if it falls through? I don't want to have to go through the hassle of returning the money. Can't I just keep it in my drawer until after we know that the transaction is moving forward? 254 CMR 310 says no. Any money that's received by you or your broker during the pendency of a transaction needs to be immediately deposited into a bank escrow account. And that immediately language is very important. That's not 3 to 5 days, not 10 days after the inspection period has passed. It definitely needs to be done as soon as possible, immediately. Only the licensed real estate broker can hold escrow funds or be a signatory on an escrow account. This means that it can be the broker of record or it can be any associate brokers within the office, but it cannot ever be a salesperson or somebody who is unlicensed, such as a bookkeeper or a CPA. You need to make sure that if you have a stamp that has your signature on it as well, that again, only the broker of record or associate brokers have access to that stamp and have control over those escrow funds. So what happens when there's a dispute over escrow funds? This is a question that often comes up. Transactions don't come to fruition for whatever reason. So who gets the money? How do you decide? The purchase and sales agreement contains language protecting the escrow agent in the event there's a dispute. The MAR form, if you look at the language in there, provides that funds are only to be released upon a mutual agreement of the parties. If you're unable to obtain a mutual agreement of the parties, you definitely need to wait until there's a resolution either from the parties or from a court. Typically, you do not want to be making that decision yourself. So hold those monies until there is a direct guidance either from a court or from the parties in that transaction. The follow-on question to releasing the funds is, can a property be relisted if there are still escrow funds that are being disputed? And unfortunately, there's no clear answer to that question. It's maybe. It's really a fact-intensive situation. I would certainly advise any seller who is considering relisting their property when there are disputed escrow funds from a prior transaction to consult with an independent attorney and determine whether they will be exposed to any liability in doing so. Really, the situation you don't want to find your seller in is if there's a disputed escrow funds, and additionally to those disputed escrow funds, the property itself is disputed. Is that buyer going to potentially sue for specific performance, and are they going to be able to hold the seller to that original contract? The problem in that situation is then the seller, if they do decide to relist the property and enter into an agreement with a second buyer, they may potentially be bound to sell that property to two individuals, and that could certainly land them in a lot of hot water and expose them to a lot of liability. So that's why we recommend, if there is a dispute and a transaction falls through, before relisting that property and definitely before entering into a new agreement, consult an attorney. We hear a lot about advertising, what's required, what's not required, whether things are in compliance. And so you'll see on your screen that there are regulations both in 254 CMR 3 as well as the Realtor Code of Ethics, Article 12, that covers what needs to be addressed in all of your advertisements. You need to make sure that each and every advertisement is not false or misleading. Needs to identify your identity as a real estate salesperson and include the name of your broker. Salespeople cannot ever advertise in only their own names. It always needs to include the name of the broker. And of course, you can't discriminate in any of your advertisements. That was a big issue this year with Facebook and fair housing. Facebook advertisements allow you to narrow the audience of any advertisement that you post on there. And many of the categories they allow you to select are protected by fair housing. So certainly be cognizant of that. Just because it's available as an option does not make it a good option. So make sure that you're never discriminating against anybody. Many of your offices are also going to have individual policies as far as how the brokerage is going to be displayed on those advertisements, a size ratio. That's certainly up to an office by office basis. It's not anything that's regulated either by Massachusetts laws or through the Code of Ethics, whether there needs to be a certain size ratio, but certainly it does need to be conspicuous. So you don't have the brokerage name in size 6-point font on a sign. So just be cognizant of that as well. Oh, just one more thing I wanted to touch on. The Realtor Code of Ethics says that if you're advertising in a medium online, that you can't include all of the necessary information in that field. You may include a link to a web page that includes all those required disclosures. As it currently stands, that is not consistent with Massachusetts rules and regulations. So be cognizant of that as well, that you want to make sure that it's all included where somebody's going to be able to see it, because the Code of Ethics is not consistent with Massachusetts laws there. Advertising pertaining to teams is basically the same as everything we just went over previously. There's not any specific rules as it currently stands in Massachusetts relating to teams. The one thing I want you to make sure that you keep in mind is that teams are not brokerages, so they need to make sure that they're not holding themselves out as such in their advertisements. It's definitely an emerging area that is sort of fraught with issues. That it's a very gray area, unfortunately. We don't have a lot of guidance at this point, so be particularly aware of the advertising rules when applying them to teams. Again, obviously, everything needs to be honest and truthful and has to include the name of the broker. The team leader is not necessarily the broker, so keep that in mind as well. You need to make sure that your advertisements are presenting a true picture as well. So again, that goes back to don't hold yourselves out as a brokerage. If you're a team, clearly identify who you are, who the team is, and who the brokerage is. All of those things should be clearly and conspicuously disclosed to any prospective buyer to avoid any potential 93A claims or anything along those lines. If somebody is, alleges that they were deceived and they didn't know this team was part of a brokerage and they thought they were a standalone. Teams also should not be holding escrow funds. Those still need to be going to the broker of record with the firm. In conjunction with teams, I wanted to touch a bit on the Massachusetts laws and regulations regarding real estate corporations with the tax reform that went into place at the beginning of this year. We got a lot of people inquiring as to whether a salesperson could set up an LLC or an S Corp or anything along those lines to receive their payments. Massachusetts laws don't allow a salesperson to establish an LLC or S Corp or anything along those lines to receive their commissions. Only brokers are able to receive corporate licenses, and those entities do need to have a broker's license. So you'll see on your screen the law and regulation that cover licensing of corporations, LLCs, partnerships. Those entities all need to have a license. Payment to an entity that does not have a license could land you in some difficulty, as you'd be sharing a fee with an unlicensed individual or entity. So unfortunately, as it stands right now, that's only available to brokers. Again, it can be an associate broker. It does not have to be the broker of record. But if you are an associate broker looking to do this, I would talk to your broker of record and make sure that they are okay with you setting up your own corporation simply to facilitate payments. If you're a broker of record and you have associate brokers under you, I would recommend considering establishing an office policy that addresses this and touches on what that corporation established by an associate broker can and cannot do. Disclosure is one of the favorite topics we get on the hotline. People are always asking if a certain thing needs to be disclosed or does not need to be disclosed. Chapter 93A states that it's a violation to fail to disclose to a buyer or prospective buyer any fact the disclosure of which may have influenced the buyer or prospective buyer not to enter into the transaction. So what has to be disclosed? Known facts. And of course, what a fact is depends on the qualifications of the person who's the source of that information. If a neighbor tells you that the well has poor water quality, that might not necessarily be a fact. But if you have a well test done and it comes back that it's poor water quality, if that was done by a qualified individual, certainly that would be a fact that you would want to disclose. You as real estate agents do not have any duty to discover problems, and I certainly wouldn't recommend undertaking to discover any problems, because then you're put in a difficult position of having to disclose anything that you do discover. Lead paint for properties built prior to 1978, you always need to make sure that you fill out the lead paint disclosure form appropriately. We get a lot of questions about how to appropriately fill out the form, so if you have any questions, certainly feel free to call the hotline or seek guidance from somebody else. If the property has a septic system, that also needs to be disclosed to potential buyers. Off-site conditions. This is a tricky situation that we've been getting a lot of questions on lately, as far as if something's off-site, when is that required to be disclosed? And there's a case that states any off-site conditions that are unknown and not readily observable to the buyer, and the existence of those conditions is of sufficient materiality to affect the habitability, use, or enjoyment of the property, and renders that property less desirable or valuable to the objectively reasonable buyer. That's when it needs to be disclosed. The situation that I think probably is most common with this type of disclosure would be a Superfund site, or if there was a underground storage tank in the adjoining lot, anything along those lines that's not on the property that you're selling, but is nearby and could potentially affect that property in that manner, that would need to be disclosed as well. And of course, if you are asked any direct questions, you want to make sure that you're truthfully answering those questions. Some top topics that we get questions about are paranormal occurrences, whether there's been a death on the property. Those fall under the stigmatized property statute. And there's no affirmative disclosure requirement for either of those things. Of course, if you do have knowledge of either of those, and you're asked about it, you would need to disclose it in that situation. But again, you're under no obligation to discover if anything along those lines exists on that property. But if you're asked about it, you certainly want to answer truthfully. Crime statistics. A lot of buyers want to know, is this a high crime area? What's the, rate of violent crime? How are the schools? Those sort of things. Any of those questions, you want to be the source of the source. So be able to point them in the direction of where they can find the information that will answer that question. Point them to the local police department. Point them to, a website that they can, look up area, crime statistics, anything along those lines. But you don't want to be the source of that information. You also want to be very careful with things like halfway houses or rehabilitation centers, anything along those lines. You could be running up against fair housing, as that's a protected class. So again, be the source of the source in those situations. Procuring cause is probably one of the top 5 questions we get on the hotline. Often, it's leads to a commission dispute. How do you determine if somebody's the procuring cause to for a transaction? So you'll see on your screen a couple of definitions that I included on there. Determining procuring cause it's a multifaceted analysis that I'm not going to go over every category that's reviewed in a procuring cause determination, but it's really fact intensive and it's determined on a case-by-case basis. There's not a single element, so to speak, that's going to say yes or no, you're the procuring cause in a situation. In order to establish procuring cause, it has to be something beyond a simple agency relationship. So just because you filled out that agency disclosure form doesn't necessarily make you the procuring cause for that transaction. However, it can certainly be one element that is considered in determining who the procuring cause is. In order to establish that you are the procuring cause, you need to demonstrate that you made reasonable efforts to develop and maintain an ongoing relationship with that purchaser. Sometimes there are situations of abandonment or estrangement that may come up that break that chain of events. And really what you're looking to establish is an unbroken chain of events that led to the successful culmination of the transaction. So if a broker's inactivity or your perceived inactivity may have caused a purchaser to think that you lost interest or did not want to proceed with the transaction, that's abandonment. If the broker's conduct or failure to act when necessary caused that purchaser to terminate the relationship and move forward with another agent, that would be an estrangement situation. So there's a lot of factors that go into establishing procuring cause, but these are just some of the main issues that I wanted to cover on that topic. Nanny cams. So we already, discussed this a little bit, but I wanted to touch on it again because it's so important. That it's a crime in Massachusetts to secretly hear or record another individual without their knowledge and consent. So absolutely make sure that you are including information on any recordings, both in MLS and at the property itself, with a sign on the door or before a prospective buyer and their agent would be entering the property. Alternatively, if the seller does not want to disclose that their property is being recorded because they don't want people to know what their security system is, you should advise them to unplug any of those or deactivate any of those devices prior to anyone entering the property. So I sped through that a little bit. So I think if we wanted to go to some questions now, hopefully we've got a good bunch over there.
Yep. Thank you, Catherine. We have a few questions already. Please remember that we will refrain from answering any specific personal legal real estate questions. You can call the MAR customer service line and speak to the legal hotline for legal real estate assistance. First question, can a salesperson set up an LLC to receive their commissions?
So as it stands currently in Massachusetts, a salesperson is not able to set up an LLC. That's only available to brokers at this point. I know there are several other states that allow salespeople to set up some sort of business entity simply for the purpose of facilitating payments as opposed to engaging in any brokerage activities under that LLC, but as it stands in Massachusetts, that's not the case. So unfortunately, if you want to be able to do that, you need your broker's license.
Great. Is the recommendation for a sign as to recording on the property limited to open houses only if the MLS listing discloses? That is, the MLS listing would put agents and therefore their clients on notice or any accompanied showings.
So I would definitely recommend that any signs or any properties that are under surveillance in that manner be disclosed both in the MLS as well as through a sign. The risk that your seller is potentially going to be exposed to if it's only exposed in the MLS is that the agent may see that, but the buyer or their buyer client may not see that information. And you want to make sure that all individuals are aware of that. So that's why our recommendation at this point is to include it both in the MLS and a sign on the property, because even in the event, it gives that buyer several opportunities to determine whether they still want to enter that property and be subject to recording, or request that that seller disable that recording equipment while they're on the property. But it allows them to appropriately respond to how they want to move forward.
Okay, next question. When is an LOI used versus a contract to purchase on commercial property?
Can you repeat that for me, Sarah?
When is an LOI used versus a contract to purchase on commercial property?
I'm not certain on that question, so if you can either call the legal hotline or email the legal hotline, I'm happy to look into that, but off the top of my head, I'm not familiar with that.
And are deeded beach rights needed to be disclosed?
Yes, I would absolutely disclose if there are deeded beach rights, because that's certainly something that's going to be a material fact that's going to impact a prospective buyer's decision to enter into that property. So absolutely, I would disclose that.
And the next question, confirming that if a buyer comes through my open house, that does not make me a dual agent.
Not necessarily. So if a buyer comes to an open house unrepresented, it doesn't necessarily make you a dual agent, but depending on your agency relationship with the seller, you could potentially enter into a dual agency situation with that buyer. Or if they wanted to submit an offer using you and did not want to do dual agency, you would just treat them as a consumer as opposed to a client.
These next couple questions might have to call the hotline, but you can just determine that. How do I fill out agency disclosure for buyer who comes to my open house and puts in an offer?
Again, that would be determined by the specifics of your relationship with the seller. You could represent them in a dual agency capacity, or you could treat them as a consumer. If you were treating them as a consumer and not a client, you would just provide them a copy of your agency disclosure with the seller.
Okay. And the next question is very detailed. I will forward that to Catherine, and someone from the legal hotline will reach out to you. We'll take a few more seconds for people to type their questions if you have any.
Something else that I didn't get to that I wasn't sure if we'd have time for, depending on number of questions, but I can certainly touch on now, is the difference between emotional support animals and service animals. This is a question that's been coming up a lot lately, and there's a lot of questions surrounding it. So if anybody comes to you with either situation, either in a landlord-tenant situation or an open house even, or with a condominium association or homeowners association that might have a restriction on pets, an individual who requires either an emotional support animal or a service animal are going to be protected under the ADA and should be provided the opportunity to request a reasonable accommodation. And you want to make sure that you never ask them what their disability is that they require that animal for. So you can certainly say, what is your animal trained to perform? You can certainly hold that animal to certain standards. For example, not biting anybody, cleaning up after the animal, keeping it on leash on the premises. Those are reasonable restrictions to be placed, even on a service animal or emotional support animal. But you want to make sure that you're never rising to the level of discrimination with that. So I wouldn't flat out deny it without getting additional information and determining that it's, if their request for a reasonable accommodation is in fact reasonable. As a landlord, you never want to charge any additional monies or require additional insurance for an individual who has an animal that is either an emotional support animal or a service animal. So just be very careful of that. There's a pretty common misconception that there's a difference between emotional support animals and service animals. And as far as what they perform, there is a difference, but they're both protected under the ADA, so proceed very carefully in those situations.
Thanks, Catherine. We have a question from one of the local boards. They've had a few members ask about marijuana and their home's proximity to a school zone. What are the potential risks for these folks?
So, as we all know, marijuana is legal in Massachusetts. It is, you're able to use it for personal recreational use as well as medical use. I believe that the use is limited to your personal property, so there's certainly no public consumption of it. So I don't know if the question is related to proximity to one of the places where you can purchase it, or if a neighbor uses it. Did it specify, Sarah? I'm sorry.
No, it did not specify.
Okay. So I'll just touch on as far as a landlord-tenant situation. MAR does have a smoking addendum for leases that includes both smoking of cigarettes and marijuana, that landlords are able to prohibit that on their properties. Certainly landlords may want to consider doing that. It is still not legal under federal regulations. So if a landlord receives any sort of federal funding, they should consider instituting a policy so they don't potentially lose that funding.
And as for emotional support dogs, in Massachusetts, all one has to do is apply online and get a certificate. Can they ask for a doctor's approval? Do you know?
So as far as the emotional support animals go, it doesn't have to be a doctor's. No, it can be a verification from somebody with firsthand knowledge of that individual's need for it. So it can be a therapist, it can be a close family friend, it could be a priest or rabbi, or someone along those lines. There certainly have been a lot of abuses of the system because it is very easy for somebody to get an animal certified as an emotional support animal. At the NAR convention, I did go to a panel on this and was advised by HUD that they're hopefully going to be issuing some additional guidance on emotional support animals versus service animals, excuse me, and the requirements and what landlords are going to be able to request for documentation. But as it stands now, it's very difficult to distinguish between them, and it's very easy to get the proof that's required as the law currently stands. So I would always recommend that you proceed very carefully when and if you encounter somebody who says they have a service animal or an emotional support animal. If you have any doubt of whether it's legitimate, you can always reach out to HUD. You can always reach out to MCAD, which is the Massachusetts Commission Against Discrimination. Ask them for some guidance. Again, you could always call the legal hotline here as well. I'm happy to talk it through with you. But it's definitely something you want to proceed with caution on.
Okay. Can a landlord decline because of a criminal felony history? Is there a time limit after the time has been served that it's no longer an issue, or is it forever?
So there's not a bright line test on that. So if you're going to be running somebody's criminal background, you want to make sure that you have a consistent policy that you're doing that for all prospective tenants. So if you're going to run a query check, do a query check on every prospective tenant that you have. If you want to have a policy that says that you're not going to allow people with a criminal history to reside in the property, you can certainly do that as long as it's evenly applied across the board. The risk you run of, is if you have knowledge that somebody does, let's say, have a violent history, and then one of the other tenants was injured as a result of you allowing that, could potentially expose you to some liability. So you can certainly get that information. You can certainly use it as one of your criteria to screen tenants on. Criminals are not a protected class, so absolutely.
Okay, looks like that's all for questions today. As a reminder to everyone, this webinar has been recorded and it will be available to view in a few days on the MAR website. And thanks for joining, everyone.